This presentation will cover the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005, which is found in Chapter 18 of Dynamic Business Law. In order to understand why the act was signed, we must understand what bankruptcy is, and bankruptcy is defined as a legal procedure for dealing with debt problems of individuals and businesses, specifically a case filed under one of the chapters of Title 11 of the United States Code, which is also known as the Bankruptcy Code. If an entity is unable to pay its debts, bankruptcy law provides various options for the entity to resolve those debts. Bankruptcy remedies are available to individuals, partnerships, and corporations. There are two very general laws, both federal laws, to bankruptcy. Um, those involved are entities, which are persons, partnerships, organizations, or businesses that have legal existence. First, the debtor is an entity that owes money to another entity. A creditor are entities whom a debtor owes money, and an insolvent debtor are debtors who cannot pay their debts in a timely fashion. The bankruptcy laws provide protection to creditors. They ensure that creditors competing for a debtor's assets are treated equally and receive a fair share of the debtor's assets. The second law provides opportunities for debtors to gain a fresh start financially. They provide an organized method by which insolvent debtors respond to debts. Title 11 of the United States Code, or the Bankruptcy Code, is divided into chapters. Each chapter is divided into subchapters, um, covering rules, those involved, and procedures for each situation. Chapters 1, 3, and 5 are really just general guidelines to the Bankruptcy Code. Chapter 1 being general provisions, Chapter 3 being case administrations, and Chapter 5 being what we talked about in a previous slide of the creditors, the debtor, and the estate. Chapter 7 is the sale of the debtor's assets by a trustee and the distribution of money to creditors, also known as liquidation. Chapter 9 is the adjustment of municipalities' debts. Chapter 11 is the reorganization of the debtor's financial affairs under supervision of the bankruptcy court. Chapter 12 is the reorganization of a family farmer's debt. Chapter 13 is the reorganization of an individual's debts. And Chapter 15 is the recognition of insolvency proceedings pending in a foreign country and relief for foreign debtors. Um, from the, the Bankruptcy Abuse Prevention and Consumer Protection Act of 2005, the main chapters that were focused on were 7, 11, 13, and 15. Focus on what the Abuse Prevention and Consumer Protection Act of 2005 was all about. The act was signed April 20th, 2005, and became effective that same year on October 17th. At first, it received an enormous amount of positive and negative media coverage affecting consumer bankruptcy because it did affect Chapter 7, 11, 13, and 15, which all have to do with have a lot to do with individuals. Um, Provisions created new opportunities and obligations for debtors, and really set traps for unwary practitioners, especially those who were serial filers, filing more than once, um, to keep them away. Again, it mainly influenced chapters 7, 11, 13, and 15 of the Bankruptcy Code, and it provided more protection to creditors, ensuring they were treated equally and received a fair share of the debtor's assets, and also provided more opportunities for debtors to gain a fresh start financially, um, with more organized methods to respond to debts. Now we'll focus on what the provisions of the Bankruptcy Abuse Prevention Consumer Protection Act of 2005 were. First were real property leases. These required detailed debtors to quickly decide to assume or reject site and store leases. The Act gave the past 60-day period and extended it to 20-day period with a 90-day extension for the debtor to decide if they will further the lease. Uh, the reclamation and similar claims, um, they provide sellers of goods with sustainable enhanced rights to payment. Um, First, this administrative expense priority accorded claims for goods delivered within 20 days of the petition date. Second, the seller of goods received by a debtor within 45 days of the petition date can submit a reclamation demand to the debtor within the later of 45 days after receipt of the goods or 20 days after the filing. Next, we'll look at the executive compensation. This prohibits payments and obligations to an insider. It's pretty much um, its severance for executives is similarly limited. Um, it permits the avoidance of a transfer to an insider under an employment contract, irrespective of the debtor's financial condition or solvency at the time of the contract. Looking at utilities, this enhances the rights of the utilities by providing that their entitlement to accurate assurance um, under the bankruptcy code requires payment of cash or a similar deposit. The Act provides that prior payment history, proof of post-petition financing, and allowance of an administrative claim cannot constitute adequate assurance. The preference claims greatly enhance the ability of recipients of potential preferential transfers to defend against avoidance actions brought by debtors and trustees. The Act amends current practice by permitting a debtor to show either that the payment was in ordinary course of both parties or according to ordinary business terms in the industry. Official committees are grant courts the authority to direct the U.S. trustee to modify the composition of an official committee if necessary to ensure adequate representation. Uh, the provision is almost certainly going to give a rise to litigation early in cases as frustrated candidates for committee membership take their grievances directly to the court. Investment bankers, um, under the new act, um, it increases opportunities for investment bankers to make them not disinterested and thus not eligible to serve as a professional to a debtor. If the banker was a unwriter for securities of the debtor within 3 years of the petition date, the Act would appeal this probation. Sharing of information requires committees to provide their constituents with access to information received from the debtor. Um, the Act will not be construed to prelude a requirement that creditors may receive such information only upon existing of satisfactory confidential provisions. Some additional provisions. These are mainly focused on Chapter 7 of bankruptcy law. Uh, the means testing, this was highly controversial when it first came out, but it's really the comparison of the debtor's income to the median income in the individual's domiciled state. Serial filers really crack down and address the situation of multiple filings by the same debtor. Um, it's become very common for debtors to file Chapter 7 and then convert to Chapter 13. So the Act really cracked down on these serial filers. Credit counseling, it calls for the debtors to show documented good faith effort to obtain and implement debt counseling. Um, these these changes will increase the cost of filing any type of bankruptcy action, and some have projected that the related legal fees will more than double. Retirement funds, the Act reinforces the protection offered by tax exempt employee Retirement Income Security Act qualified retirement funds. While retirement funds have been ruled exempt from bankruptcy on a number of occasions, the act actually makes uh, the exemption explicit. Looking at super discharge, it includes any tax indebtedness due to failure to pay, as well as penalties for evasion and non-payment. It also addresses consumer protection and related abuse by bankruptcy professionals. Uh, International bankruptcy. This is mainly focused in Chapter 15 of bankruptcy. It addresses cross border bankruptcy as an entirely separate category of filing. It was one of the most important amendments for businesses in the Act. And all other business related issues, creditors may ask a debtor in bankruptcy for the return of inventory shipped, but for which no payment has been received. So um, the period for the reclamation was extended from 20 days to 45 days in order to help out creditors. The effects of the act were extremely impressive, um, especially in the first year from 2005 to 2006. As you can see in the chart on the top left, the bankruptcy rate was predicted to stay pretty even, but you can see the spike completely downhill in 2005. It is gradually rising, but the act of 2005 definitely put a halt to the bankruptcy rate. Uh, the graph right below it, the bar graph, shows the consumer filings. Again, there is quite a drop from 2005 to 2006. It is on the rise again, so it seems that the bankruptcy rate is rising up, but the act did its purpose in 2005. Um, you can see again to the chart on the bottom right hand side that both non-business and business filings were way down after the act was signed. Again, going back up. And the chart on the top right just gives a rundown of what the act did for bankruptcy in 2005. It put a halt to a lot of bankruptcy filings, starting from the top with consumer debt, monthly income, and family income. Um, so based on median uh, expenses, disposable income, special circumstances, all these things were in play when the act was signed in 2005 to try to get bankruptcy claims down. And that concludes my presentation. I thank you all for listening.